Okay, can you hear me? Thank you. And thank you to this committee and to all the patient people behind me and in the corridors. I want to keep this relatively brief because I want to be deeply respectful of both your time and the many other people who are here to testify this evening. And I know that you've heard me speak in the past, and some of these issues are not unfamiliar to you. So I'm choosing not to chase Mr. Sicoccio into the rabbit hole of exceptions where everyone is a Boy Scout with a BB gun. Suffice it to say, I am going to go over briefly some of the bills that we are in support of, and then I'm going to slow down and talk about some that we oppose. I'm going to leave some of the substance of this work to be addressed by my colleagues. I'm Julia Wyman from the Rhode Island Coalition Against Gun Violence. I am here both as a parent of two school-aged children and the coalition. We support House Bill 7199, seeking to ban high-capacity magazines. I want to pause for a moment because I know, Representative Costa, that you talked about your love of sport and use of high-capacity magazines in your sport, and I imagine a lot of people here agree with you, and I think that's great that you have that outlet. We don't oppose that. I just think that there has to be a balancing of interests. And so when we think about the number of people who can be, killed from these same means of ammunition versus your desire to be a sports enthusiast, I think we have to find some kind of balance. The reason why we selected 10 rounds is because that's been upheld as constitutional by many of our neighboring states, but it's also the key number that when an active shooter is using this ammunition and they're shooting at a crowd of people and they have to reload their clip, that is valuable time that, persons can maybe subdue the shooter or, escape the room, like, in fact, what took place in the shooting of Gabby Giffords, the Congresswoman Gabby Giffords in Arizona, and then in the Sandy Hook massacre where several children escaped the room when Adam Lanza had to stop and reload. So that's the reason why we're going after that number, which, again, has been upheld as constitutional. Mr. Sicoccio talked about the sunset provision in the 1994 ban, which expired in 2004. Then he commented, well, maybe we need these ammunitions to help deter, gun violence or criminals. I respectfully disagree. And while I was sitting there waiting for his lengthy testimony, I had an opportunity to go through some of the stats that I have on my iPhone. Since 2004, there have been 15 mass shootings, resulting in 336 deaths. That is why we seek to ban high-capacity magazines. And I think that Rhode Island is a fabulous state. We are a leader in terms of our gun laws, which directly correlates with why we have such a low gun death rate in our state. I think that we should take the extra measure, join our neighboring states, and seek to ban this. And I think that we can do this, as you mentioned, Representative Costa. That's a way that's mutually beneficial to all of us. So thank you for making that comment. Secondly, the coalition supports some combination of House Bill 7283 by Representative Amore, which roughly mirrors the federal law, coupled with some version of House Bill 7575 by Representative Tanzi, insofar as it calls for an automatic surrender provision in the context of restraining orders. And we think that, and we're optimistic that with both the governor, the Attorney General's office, the DV and gun violence prevention groups, the law enforcement and Second Amendment groups, who we all know have sat at this table with us, that we can, maybe come to one unified bill that addresses all these concerns. I don't think it's useful for us to poke away at the very little minute issues and say, oh, we can't get this done this year. Of course we can. And I think that with this committee's chair, with the use of your convening powers and your excellent moderating skills, that we can come up with such a bill. And I would be really proud to participate in that. So thank you. I want to move on to the bills that we are opposed to. We are opposed to, let me pause, actually, there's one more that we support, and that is Representative Agello's Bill 7243, the banning of concealed carry permit holders in K-12 schools. There are 9 states that allow concealed carry permit holders to carry in schools, and they all contain significant limitations, such as specialized training, where if, let's say, a teacher is being armed with a firearm, they have to provide notice in many instances to their governing management within the education community. So whether it's a superintendent or a principal, there has to be some kind of identification. They go through extensive training, far more than an average CCP holder. And I would just mark that Rhode Island's law is completely unfettered discretion to go in schools without any specialized training. One of the members of my board, Joe Taveras, will talk in detail about why that's so very important, but I just want to mention that as a mother of two school-age children in public schools, I respectfully do not want Mr. Sicoccio or any of his colleagues protecting my children. My money rests with the good judgment of police officers and school administrators who've come up with plans that help to keep our children safe. I would like to, on a related note, move on to Rhode Island's, our opposition to H7390 by Rep. Lima. This is a bill that completely overrides and replaces existing concealed carry permit laws with loose standards that, if enacted, would actually open the floodgates of concealed carry permit holders in Rhode Island. Also, while I was on my phone, I just looked up that according to the American Journal of Epidemiology, 12% of Rhode Island households own firearms. That's, to my math, 121,396 people. If we accept Mr. Sicoccio's estimate, which I think is true, about 4,000 concealed carry permit holders, that means we could basically, by enacting this law and the way it's stated now, invite over 117,000 people to become concealed carry permit holders in the state without any discretionary judgment by chiefs of police or the Attorney General's office. I would offer that that's extremely dangerous. I would also say that I find that the explanation section of this bill is misleading. It claims that it's seeking to allow for a judicial review of adverse decisions and a timely review. It goes way beyond that. It literally strips police chiefs of discretion. It imputes the definition of what is a suitable person. It basically means anybody at all who is not a gang member, but who has not been precluded by state law. That's a lot of people. Let me describe some of those types of people that we might not want carrying firearms in our public spaces. What about the gentleman who has been called to address the police have been called to his home to address domestic violence situations where the wife has not testified against him or is afraid to, or the repeat offender who has had drinking and driving problems. These are not people necessarily that we want carrying firearms in our public spaces. Or what about people who've not been adjudicated mentally unwell, but there's some suspicion about strange behaviors? Do we really want to have that kind of unfettered licensing of people within our community? I really don't think so. It also goes on to describe a lengthy and expensive and burdensome process of administrative review. It's not just merely an adoption of the Administrative Procedures Act, as Mr. Sicoccio suggests. The police chiefs that can be challenged, and they have to provide a great detail of information about what led to their decision, and then undergo an actual process of hearing that person's grievance. Think of 117,000 people having a grievance, how much that would clog, the police houses with complaints, and having to ensue a process on top of, by the way, what already exists by law, a means of appeal directly to the court system, which, as he has stated, has been used. Why do we need to add more burdensome, costly process to this? Similarly, the bill restricts what AGs may consider under its may issue authority by basically imputing that same suitable person standard. And so while it doesn't come out and address this issue, that they're trying to circumvent that may issue language, in fact, they are by creating this very low bar standard within the definition itself. So for all those reasons, I say that on behalf of the coalition that we are adamantly opposed to implementing that bill. I'll pause there and take any questions. Do you have any questions about our position?
Any questions of Julia so far? No. Take a minute if you need it, Julia.
Thank you. No, I'm fine. We also oppose House 7093 by Representative Falella individually and as a subset of what this other larger bill does, which is basically to use an automatic renewal process. The reason why we see that problematic is that currently under our concealed carry permit statute, if you're going to go for a renewal of that statute, you have to go back and basically reapply. And we understand that that is somewhat of a burden, but again, going back to my earlier proposition, that we have to balance the scales of what's best for the public's interests. And yes, there is some inconvenience, but let's balance that against the public's best interest in being free of people who maybe are not or no longer are suitable to carry firearms. So, you know, there again, this is something that would just basically render this a ministerial act, and it ignores the possibility that after that 4-year period, the person either no longer needs their firearm in public spaces, maybe their conduct has changed due to circumstances that make them not a good candidate to carry their firearm in public spaces. These are loaded, dangerous instruments. We have to have some process in place to make sure we can filter those individuals out. So for those reasons, we oppose that bill. We also, I'll pause. Any questions on that? No. We also adamantly oppose House Bill 7541 by Representative Uchi and Chippendales, granting reciprocity to Connecticut and Massachusetts. NCCP holders who are from, quote, live fire jurisdictions. To put this in context, and this is important, there are somewhere between 8 and 13 million concealed carry permit holders in the country. And depending on who you ask, I think the number rests somewhere in between. Half of our United States are active fire requirements. But here's where it gets interesting. Not all of them have the same vetting process that we have with our May issue standard, that discretionary piece. A lot of them, in fact, use this other perfunctory standard of, yes, you're assumed adequate, absent some other extreme circumstances. So about 39 states have those lower standards. So if what we're using is this arbitrary feature of, yeah, you went through your active fire training, that allows all those people who might not otherwise be deemed adequate or the kind of people rather suitable to have their firearms in our states due to this reciprocity feature. As you can see from the concealed carry permit bill, there's an attempt to strip states from any discretion. So, you know, that's a big problem. And we definitely oppose that bill. Let's see. I just want to mention another thing about this. Rhode Island is a tourist state, and we invite over 1 million people to our state every summer. And this includes our restaurants, sporting stadiums, mansions, tourist attractions, and even our K-12 schools, if you're a concealed carry permit holder. We certainly think that that's a really bad decision for all those reasons. And we hope that this committee now sees the extremely dangerous implications of that bill. We also oppose House Bill 7680 by Representative Chippendale, also known as what Frank termed the Second Amendment Preservation Act. This is a radical attempt to nullify application of federal law and basically the President of the United States executive action set forth earlier this year. It also seeks to unfairly penalize public servants by imposing a $3,000 fine, up to $3,000 fine, for basically complying with their duties, and otherwise it disallows funding to flow through the state were it to be used for any measure, for instance, that would help to protect, you know, citizens, law-abiding citizens from dangerous people. For all those reasons, we absolutely oppose that bill as well. And lastly, we oppose House Bill 7332, seeking to destroy all records. And again, I know that Representative Casey testified about that being just a really very ministerial process, but nowhere in our statute under Title 11 does it define what is a record. And I would just argue that you really can't assert something like that in a bill and then, you know, claim that it should be eliminated without some definition. On behalf of the Rhode Island Coalition and the many tens of thousands of our Rhode Islanders we represent, we'd like to thank this committee for its time and its service and ask that you vote no on those foregoing bills and yes to the three that I support.